So the Supreme Court will be considering an assault weapons ban case. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again uphold our Second Amendment rights, go ahead and hit that like button and subscribe. Also want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, an assault weapon ban case is now up for Supreme Court consideration. The case we will be talking about is Bianchi v. Frosh. The case is asking the United States Supreme Court to strike down Maryland's unconstitutional ban on so-called assault weapons. As you would expect, if the Supreme Court takes up this issue, it would have major implications not just for the state of Maryland, but also other restrictive states that have assault weapons bans, like the state of California and the state of New York. Now for some quick background on this case, the state of Maryland identifies certain rifles as so-called assault weapons. Maryland bans the sale, transfer, or possession of semi-automatic centerfire rifles with detachable magazines and two offending features, like a folding stock, grenade launcher, or flash suppressor. It also bans a semi-automatic centerfire rifle with a fixed magazine that can accept more than 10 rounds. The state also bans semi-automatic centerfire rifles that have an overall length of less than 29 inches. And to top it off, they also ban a specific list of make and models. 45 specific types of rifles are actually named on that list. These laws were challenged in the Maryland District Court. In the complaint, the plaintiffs conceded that the Second Amendment claim was foreclosed at the district court level by a prior Fourth Circuit decision on this very issue. A prior case, Colby, actually challenged Maryland's assault weapons ban. In that case, the district court upheld the law using intermediate scrutiny. On review, a divided panel in the Fourth Circuit concluded that these rifles are protected by the Second Amendment and that the ban substantially burdened the right to self-defense within the home. On that basis, they struck down the ban using strict scrutiny. Well, the state of Maryland didn't like that, so they sought an en banc rehearing in the Fourth Circuit. On review, the en banc panel in the Fourth Circuit upheld the state's ban, finding that these rifles are outside the ambit of the Second Amendment because they are useful in military service. This Bianchi case conceded that Colby is the controlling precedent, but that it is incorrect and should be reversed. The district court in this case, Bianchi, ultimately dismissed the complaint for failure to state a claim because of that prior precedent. That dismissal was then appealed up to the Fourth Circuit, and the Fourth Circuit once again upheld that dismissal because of prior precedent. And now this case is seeking review from the Supreme Court on this whole Maryland assault weapons ban issue and just assault weapons bans in general. The three arguments made on why the Supreme Court needs to hear this case are: first, to resolve the conflict in lower courts over the constitutionality of laws banning commonly possessed arms; second, because the decision below is flatly inconsistent with Heller; and third, because the question presented is exceptionally important. So let's take a look at some of the arguments that were made in this brief, and then I'll update you guys on something significant that has now happened with this case. The first argument made to the Supreme Court is that the Supreme Court needs to review this case to resolve the conflict in the lower courts over the constitutionality of laws banning commonly possessed arms. In this section, it is argued that lower courts are all over the place and divided on the constitutionality of these types of bans. The Fourth Circuit has the Colby decision that I mentioned prior that has upheld this type of ban using intermediate scrutiny. That type of analysis has been followed by other types of circuit courts, including 5 other circuits in the 1st, 2nd, 3rd, 9th, and in the DC circuits. All these circuits have upheld similar bans on common arms using a watered-down intermediate scrutiny analysis. In contrast, you have courts like Massachusetts and Illinois Supreme Courts, which have followed the categorical approach. These courts have held that laws which bar all civilians from possessing or carrying stun guns, even in their homes, is inconsistent with the Second Amendment and are therefore unconstitutional. They reasoned that because these instruments are arms within the protection of the Second Amendment, they may be regulated but not absolutely banned. Under this type of analysis, a state's ban on an entire category of protected arms can never be upheld. Again, very different from the tiered-based scrutiny and the tiered-based approach that courts like the Fourth and the Ninth Circuit have used. The Seventh Circuit has used a test which asks whether a regulation bans weapons that were common at the time of the ratification of the Second Amendment, or those that have some reasonable relationship to the preservation or efficiency of a well-regulated militia. And also they ask whether citizens retain adequate means of self-defense outside of what the state is trying to do. As you can see, lower courts are all over the place on the type of analysis that they will apply when looking at these Second Amendment cases. And because of that, the argument here in this petition is that it's time for the Supreme Court to finally step in and resolve this conflict. The second main argument that is made is that the Supreme Court should review this case because Colby's decision was flatly inconsistent with Heller. The argument is that the Supreme Court was explicit about the guiding test for determining the Second Amendment's applications to laws that ban certain types of firearms. The question is, has the government banned firearms that are typically possessed by law-abiding citizens for lawful purposes, or has it instead banned something that is dangerous and unusual? If the answer to that question is the former, then the ban must be struck down because of the Second Amendment's protections. The semi-automatic rifles that Maryland has banned, like the AR-15, are common under any definition. These rifles are legal in a majority of states, and there are over 20 million in the possession of law-abiding Americans across the nation. However, even the Maryland courts did not deny that they are very common, and they are common in use for lawful purposes by law-abiding people across the nation, but instead they argued that they are so similar to the M16 and those that are used in the military that they should be banned. However, even that directly flies in the face of the text as informed by history and tradition of the Second Amendment. The founders intended to protect arms that ordinary citizens would bring from their homes to the militia for duty. So to say that a state can ban them because they could be used in military use or are similar to weapons used in the military does not find support in our history or tradition. In fact, those are the exact type of rifles and firearms that are actually protected by the Second Amendment. The last main argument made in the petition is that the court should hear this case because the question presented to them is exceptionally important. And we can all agree that this issue of whether a state can outright ban an entire category of weapons that are common, very common, and are used by lawful Americans is indeed something that is exceptionally important. And the Supreme Court has kind of ducked these big issues in the past, and now it's time for them finally to address them, and that is what's being argued in this section. So that is the petition that was filed to the Supreme Court and the arguments made on why the court needs to actually hear this case. The state of Maryland then filed a waiver of the right to respond to the petition that was filed to the Supreme Court. Essentially, what the state of Maryland said is that they will not file their response until the Supreme Court actually orders them to do so, and if the Supreme Court doesn't order them to, then they won't file a response. And essentially what this means is the state of Maryland does not think this is a significant enough of an issue or case to even have to respond to. Now, the big update in this case is that the Supreme Court has actually scheduled it for conference. So on January 21st of 2022, the Supreme Court will be hearing this issue. During this conference, they will decide whether or not they want to actually take up this case, grant cert, deny cert. They could put it on hold. They can reschedule it for a different conference. There's a lot of things that the Supreme Court could do. But as of right now, on January 21st, they will get together and they will consider what they want to do with this case. Recently, the Supreme Court held conference on the PZ red flag case that we've talked about on the channel prior, which they actually denied cert on. So just because it's going to conference doesn't guarantee that the Supreme Court will take it up. They just denied cert in that PZ red flag case. That one was a little bit more muddy. It wasn't as clear of an argument that was being made to the Supreme Court in relation to red flag issues. So it's not shocking that they shot that one down, but they have put other cases on hold. They have put other cases like the Young v. Hawaii open carry case on hold. They have put the A&J RPC magazine ban case on hold as well. So they could do the same thing with this, but we will have to wait to see what they do with the conference. And usually what happens is the following week, we will get some sort of order. And if it's on that granted cert list, then they granted cert, or if it's on the denied cert, that means that they kick this case and they will not hear it. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. I cannot thank you guys enough for everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting this channel, impacting these videos, and helping me to reach more people than I could have ever thought. We've already gotten off to a good start of this year, and that's a lot because of you guys and the support you've shown me. And I'm really excited to cover more of these cases and things that are popping up. And even I'm considering starting a second channel, so stay tuned for that. I have this second channel that I've kind of built out, and I want to do more specifically gun-related stuff on that channel that maybe don't fit on the primary channel here that's kind of legal based. I want to do more like EDC stuff, gun build stuff. So I will also link the second channel down in the detail section if you want to subscribe to that as well. And I will be starting to put up videos on there that is more specific, like gun and gear related things. But again, thank you guys for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this station was built by Armed Scholars, and the station we maintain by Armed Scholars.